Good morning. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our webinar today, the financial planning aspects of estate planning, with our presenter, Senior Principal and Attorney Olivia Holcombe-Volke with Elville and Associates. I'll say from personal experience that our clients think the world of Olivia because of her extensive experience and the care and time she takes with our clients. From all the attorneys that I could have chosen here at the firm, my family and extended family have had Olivia take care of our planning over the past few years. So I think that says something about Olivia right there. So briefly, the way this will work today is you as the attendees are on mute. However, you have a voice. There is a questions panel on your screen where you can ask questions and interact with me throughout the presentation. And we'll pause to field those questions throughout as well, and at the end too. So for certified financial planners, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. And if I don't have it already, for my records and reporting requirements, please email me your board ID. And also for CFPs only, I need the last 4 digits of your social security number as soon as possible. Everyone will also receive a post-webinar email immediately after the presentation, and we ask that you please take just 2 minutes to fill out the simple survey to offer us some valuable feedback about the presentation. Share some ideas about presentations you'd like us to see offer in the future, and you also have the opportunity to request a time for a consultation with Olivia to discuss your planning needs. So we look forward to being a resource here at Elville & Associates for you, and there's nobody better to guide you through your planning than Olivia. So very briefly, I'd like to give you an overview about the firm and a little bit of background about Olivia. So let me go ahead and pull that up. So our firm was founded in 2010. Let me actually share my screen here. That would be helpful. Our firm was founded in 2010 in Columbia by managing principal, president, and senior and lead attorney Stephen Elville. Our practice areas are plentiful. They include estate and special needs planning, elder law and elder care planning, estate and trust administration, business and succession planning, asset protection, guardianship and litigation, and tax planning. We have 7 attorneys, 12 staff members, and 5 locations. I'm coming to you here from the Columbia office here in Columbia Gateway community. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We do offer a lot of education here at the firm, and we do that in a number of ways through our planning process with our clients, through over 100 educational workshops and webinars in the communities we serve each year, and also by way of our accredited client care program. We are the only firm in Maryland that has an accredited client care program through the Client Care Academy in Boston, Massachusetts. And many clients take advantage of the benefits associated with that. So Olivia Holcombe-Volke, she's our senior principal and senior estate planning attorney with Elville & Associates. Her work is centered in estate planning, elder law, estate trust administration, special needs planning, and asset protection. She's a seasoned speaker, presenting at numerous workshops, conferences, and continuing education events each year. Named to the Maryland Rising Stars list by Maryland Superlawyers in 2017. Named 10 Best for Client Satisfaction in Estate Planning by the American Institute of Legal Counsel in 2018 and 19. And we're very proud of Olivia's volunteer work here at Elville & Associates. She is very busy, a board member of the Women's Law Center of Maryland, chair of the Judicial Selections Committee, and a volunteer attorney at the Maryland Volunteer Lawyers Service, a founding member of the MVLS Community Advocacy Network, named the Volunteer of the Month for May 2019. And she also provides training to volunteer attorneys on advanced directives, financial powers of attorney, wills, and deeds. So you're in very good hands today with Olivia. And I'm going to go ahead with that, all that being said, and turn it over to Olivia. But first, I'd like to provide a brief poll to see what has brought you here on this to-be snowy day here in Maryland. So the question is, what is your primary interest in today's webinar? So I'm going to go ahead and launch that poll. And the choices are, I have no planning and felt this would be a good start. Secondly, I have a plan, but my financial picture is not defined in it. Third, I'm an advisor here to learn to better serve my clients. And fourth, I have outdated documents that need to be reviewed. So if you could take a minute to vote and give us an idea of what's brought you here today. All right. We'll give it another few seconds here. All right, with about 3/4 of the votes in place, we have 13% saying I have no planning and felt this would be a good start for it. 38% say I have a plan, but my financial picture is not defined in it. 42% saying I'm an advisor here to learn to better serve my clients. And finally, 8% saying I have outdated documents that need to be reviewed. So thank you for participating and welcome. I'm going to go ahead and turn the screen over to Olivia so she can share her presentation with you. Olivia, you should see that button pop up on your screen now.
Very good. Thank you, Jeff. And I
Okay,
clicked show my screen.
There you go.
Oh.
And I'm going to turn off my camera and mic so I'm not a distraction, and it's all yours.
Great. Thank you. See if I can get up and running. So good morning, everyone. Thank you so much, Jeff, for that introduction. I hope that wherever you are enjoying a safe and happy holiday season so far. I will say that with regard to the snow today, I'm looking out at Baltimore City and have yet to see a flake fall. I did enjoy my favorite news article title yesterday was Baltimore area expected to get 2 to 18 inches of snow. How's that for a prediction? I think we can agree that being a weather predictor is probably a harder job than estate planning and financial planning. So the purpose of my presentation today was really motivated by realizing over the course of my practice in interacting with clients and in interacting with financial advisors and other professionals in that field, there seemed to be a decent amount of confusion about the overlap and interplay of estate planning from a legal perspective and estate planning really covering more than just what most people assume is meant by that term. Estate planning also meaning asset protection planning, tax planning. So estate planning from a legal perspective, frequently I've interacted with clients and professionals in the financial advising world who don't necessarily see that there is overlap and what relevance financial planning may have when thinking about estate planning. So that's the purpose of my topic today. Of course, as with every presentation, I won't be able to cover every possible question or every possible nuance, but what I'm hoping to do is to at least cover them in a macro way and introduce everyone to the various concepts that may warrant a little bit further thinking and certainly welcome further discussion with me. So the starting point is what is meant by the term financial planning? What do I really mean when I say that? And financial planning is a comprehensive analysis of goals, risk tolerance, life stage, and family, health, and personal circumstances, and then taking into account suitable investments, including insurance and general savings, and then taking into account and planning for budgeting and certain tax planning aspects, with the ultimate purpose of achieving one's financial goals. Simply put, it means making sure you have enough money to accomplish your goals, both during lifetime and after death. So then what is estate planning? Well, right off the bat, you notice that there's a very similar starting point. Estate planning starts by doing a comprehensive analysis of your goals, your risk tolerance, your life stage, and your family, health, and personal circumstances. Then it takes into account, what is your financial picture? What are your assets? Then we put together and determine what are the suitable legal documents, taking all of that into account in order to achieve your estate planning goals. So a brief review of what is meant by estate planning. And really with this, it means having the necessary legal documents to plan properly, which means in keeping with your goals and intentions, for the care of your health and your property, assets, finances while you are living. And of course, this is particularly relevant in the event that you become incapacitated. And estate planning also means having the appropriate legal documents to plan for the disposition of your property or your estate at your death, and the protection and care of those who are dependent upon you. So whatever it is that your goals may be, estate planning means making sure that you have the appropriate legal document structure in place to ensure that those goals are accomplished. Simply put, estate planning is having the necessary legal documents to dictate not only who will handle things for you if you are unable to, based upon incapacity or death, but also how all of those will be taken care of. So how then do financial planning and estate planning overlap? The starting point in both topics is, what are your goals? So that right there is a place where there is overlap between your financial planning picture and your estate planning picture. Starting with, what are your goals? Then the second question is, how do you intend to finance them? And ultimately, how will you ensure that your goals will be respected and accomplished if you are not able to ensure that actively yourself? I'm going to give several examples of how these three can play out in terms of financial planning and estate planning, where they overlap. So an example of a goal: I wish to age in place. What are the financial aspects of planning for that? How do you plan to finance that goal? This first requires taking into account, of course, family medical history and lifespans, your projected lifespan, the average costs of such care, and the available options for paying such costs, such as long-term care insurance, available public benefits perhaps, and maybe even just private pay from the assets that you have. What are the best investments or uses of your assets currently to plan toward that future goal? Now, this is an area, and these are questions where I don't have a lot that I can add as an estate planning attorney. This very much falls within the realm of what a financial advisor would be able to help you identify and plan in order to be able to pay for your long-term goal. Where I come in is to help with the legal documents that you absolutely want to make sure that you have in place in order to ensure that that intention is in writing and that that directive and authority is given to someone whom you trust will actually follow that directive and carry it out and be able to, based upon the financial planning that you did toward that goal. So that's an example of how financial planning and estate planning have significant overlap. Another example, you wish for your family's cabin to remain in your family. After your death, you want to make sure that the family cabin is not sold and that it will continue to be a part of your family. How do you plan to pay or have future inheritors and beneficiaries be able to pay for the costs of upkeep and taxes and maintenance that go along with real property? Thinking in terms of, I want to make sure that the family cabin stays in the family, well, that certainly requires that we have necessary legal documents in place to dictate and outline that intention to ensure that that will happen. But it also requires taking into account the costs and expenses that are a natural part of real property. And so part of the conversation that I have with clients who have this goal is making sure that there's also a source of funding that you intend to leave along with the cabin to make sure that your intentions of having the cabin stay in the family is going to be something that actually can be feasible. A third example, having your assets add to government benefits for your grandchild who has special needs. The financial aspect of this is, are there some assets that are better than others to leave to someone who has special needs and is eligible for government assistance? So that requires looking at your financial picture and determining, do you currently have an asset that may be better to leave for someone like your special needs grandchild? Or if that is a goal of yours, is there another financial vehicle that perhaps you should acquire in order to fund that goal? And then it requires making sure that you have the necessary legal documents to dictate and outline that that goal will take place after you are gone, when you are no longer able to ensure that your goal and intention is followed. Having the appropriate legal structure. And with that, it also requires taking into account, how does one leave assets for someone who is receiving government assistance without knocking them off of their government assistance? So it requires careful legal documentation and financial planning. The last example that I have as to this particular overlap of goals, financial planning, and estate planning legal documents. Wishing to minimize tax consequences after death. That's a good goal, and I'll tell you what, that's a common one. Minimizing taxes. So then the question becomes, what is the best way to accomplish that? And one financial vehicle that's frequently utilized is life insurance. So again, it requires having the conversation about the goals that you have, the priorities of those goals, and including your financial advisor or financial planner in order to be able to help guide you on whether life insurance is an appropriate investment for you based upon your financial picture to accomplish that particular goal. But in the event that it is, if that is the appropriate investment vehicle for you based on that particular goal, then an equally important thing to ensure that you have in place are the appropriate legal documents to make sure that that life insurance doesn't actually end up adding to your tax after death. And that requires careful structuring, which requires careful legal documentation preparation. Asset alignment is a piece that is vital to a successful estate plan, but that unfortunately is frequently overlooked or frequently misunderstood. Sometimes this phrase is known as funding your estate plan. But I like asset alignment because I think it's a more clear statement of what we mean when we say it. Asset alignment means making sure that the lifetime and after death access to and distribution of your assets are aligned properly with your actual intentions. This requires taking a macro perspective, a holistic view at all of your lifetime and after death goals and intentions, and all of your assets, and seeing the appropriate way to align all of them to make sure that your goals and intentions are actually accomplished with the assets that you have. Sometimes steps are skipped and sometimes shortcuts are taken. And so sometimes what happens is that with the absolute best intentions, people do things, and sometimes, unfortunately, this is also where mistakes are made based upon very good intentions, but clients may do this inadvertently, not realizing the risks that they're exposing themselves to. And sometimes financial planners may not entirely understand the risks that go along with taking these shortcuts, because the view is purely based on the financial structures rather than the macro perspective that I mentioned, which takes into account the goals, the financial vehicles, and the appropriate legal documents and risks that everyone needs to take into account. And with that, what I'm really emphasizing is how vital it is to have professionals from both areas able to assist you in accomplishing your goals, because it is only through that that you're able to ensure that you've addressed the macro perspective. So here are some examples where you see these fancy flashing caution symbols. Who knew that PowerPoint could get so fancy? One thing that I've heard regularly from people is, well, I just went ahead and made my daughter a joint owner on all of my assets. Or all of my assets are payable on death or transferable on death or beneficiary designated. That's my estate plan. I don't need to do anything further. I've done the simple approach. I don't need to worry about any complicated estate planning documents. Here, I'm not saying that these are never a good idea, and I'm not saying that these are not sometimes used in combination with a more comprehensive estate plan. But frequently, some of the risks that are attendant to doing this are overlooked, and that's what I want to mention. So with joint ownership, frequently I hear people say, I made my son joint owner so that he can access my money to pay for my care. It makes it easier for him to be able to access my money to help me out. The risks that people are often unaware of. When you add someone to an account, you have now also added their creditors. So if they get sued or divorced, you are now exposing your assets to their creditors, which was not your intention. Your intention was to make it easier for them to be able to use your money to help you, not to risk that your money would be taken because of an issue that they may have. Another risk that is attendant to adding someone's name to an asset, and this is more often a risk with real property, but it's an overarching risk that I want everyone to be aware of. Capital gains. Capital gains tax. There can be negative results from simply adding someone else's name to an asset in terms of the capital gains tax that they will face that they would not face if you had simply left the asset to them after your death. So that's a risk that needs to be taken into account, because that is often not part of what people are thinking about when they add someone as a joint owner. So this may accomplish your lifetime intention, but not your after death intentions, because by adding someone as a joint owner, depending on the type of joint ownership, at your death, it becomes their asset. And that may not have been your intention. You may have simply intended that they could access it while you are alive, but not that it would go to them at your death. And that's something that you're risking by doing this approach. An example of the risks with making all of your assets payable on death or transferable on death, frequently I hear people say, well, I did this for simplicity and in order to avoid probate. Easy. But the risks here, what if the person to whom you designated the asset is deceased at your death? So of course, none of us have the ability to predict the future, and none of us have the ability to know what the status of beneficiaries will be at our own deaths. So what if the person that you designated your asset to has passed away at the time of your death, and you were unable to update your beneficiary designation or your payable on death designation? And what's worse, you thought that you didn't need a more comprehensive estate plan because you set all of your accounts and assets up to be POD or TOD. So now the person you've left it to is deceased when you die, which results in the asset having to go through probate, and you don't have a will to direct probate where you want for it to go to ensure that it goes to your actual intended beneficiaries, because you thought you didn't need one because you had done this more simple approach. So that's a risk that's attendant to relying upon this type of structure as your sole estate plan. Typically, what is better is to combine these approaches with something that is more comprehensive. And in terms of adding someone to your assets in order for them to have access on your behalf, that is something that is accomplished using a power of attorney and sometimes a trust document. And in terms of designating things to go to someone at death, I'm not, again, saying that this is not an available approach. It's just not an approach that I recommend that people rely on completely. It's typically better used in combination with a will or a trust plan. So another common thing that I hear is, but I have a will or I have a trust. Doesn't that cover everything? People often, understandably, assume that when they put something into writing in a will or in a trust, that that will cover every asset that they have. That is not the case. Examples of when this is not applicable. If an asset has a beneficiary designation, that is where that asset will go at death, regardless of what your will or your trust may say. If an asset has a payable on death or transferable on death designation, that is where that asset will go at your death, regardless of what your will or trust may say. And with joint ownership, when something is jointly owned, and with this I will say there are particular nuances to joint ownership. So different types of joint ownership have different results when one owner dies. But one of the things that many people don't realize is that their will or trust will not cover and will not control where those assets that are jointly owned may go at death. And the flip of that is that sometimes people assume that a joint ownership means that that joint owner will inherit everything at your death, but in fact, the particular type of joint ownership that you have will not result in that. All of this is to say, again, that it is very beneficial to everyone to have the input of an estate planning attorney and a financial advisor in order to be able to look at your entire picture from a macro perspective and give you appropriate guidance on what your options are, what the risks are, and help you decide which path you want to take, taking all of that into account, and then making sure that everything is aligned perfectly, thus leading to a successful estate plan. A successful estate plan is one that follows 2 steps. The first step is making sure that you have the appropriate legal documents in place. Now, again, these appropriate legal documents are determined following a conversation about what your goals are, what your assets are, risk tolerance, all of these different things. Everything that I covered in the first few slides leads to a decision on what the appropriate legal documents are to accomplish your goals and address your concerns. And then the second and equally vital step is making sure that all of your assets are aligned with your plan, with your intentions. Because if these 2 things contradict each other in any way, and if it's not looked at from a holistic perspective, mistakes can happen and things that were not your intention can take place. So we start by having the legal documents in place, the legal structure, and then it's absolutely vital that we make sure that your assets are properly aligned in order to accomplish your estate plan, which again covers both lifetime planning and after death planning. So talking through a bit more about some nuances of beneficiary and payable on death designations, the when, why, and how to assets where this is an option and where this may be an advisable way of planning with that particular asset. So beneficiary and payable on death or transferable on death designations, first of all, that's only relevant with regard to what happens with that asset after your death. So talking about beneficiary designations and payable on death designations, here we're really talking about funding or having particular assets go to a particular place in a particular way after your death. So some examples of types of assets, which is the first consideration. Different types of assets are either appropriately handled by beneficiary designation or not. So the starting point of the consideration is, what type of asset are we talking about? For example, life insurance is a type of asset where there is a beneficiary designation, and that is where that life insurance death benefit will go at your death. There are nuances to this, though. The beneficiary designation on life insurance needs to be done properly in order to avoid exposure to your creditors. And sometimes a relevant aspect of this conversation in the state of Maryland is inheritance tax. So life insurance is definitely an asset that should be handled by beneficiary designation, but the appropriate way of doing the beneficiary designation must take into account the aspect of exposure to your creditors' claims after your death and the relevance of any inheritance tax that may be applicable in your estate plan and in your intended beneficiaries. Another type of asset where beneficiary designation is the appropriate way of handling it is with any sort of qualified or tax-deferred account, such as an IRA, 401k, TSP. These types of assets absolutely should have the beneficiary designation completed and kept up to date. And with this, the nuances that we have to take into account when we're viewing this from a macro perspective, we have to take into account the tax consequences, because that type of an asset will have tax after your death, simply because the money in it has never been taxed. And you don't get away from that tax simply by passing away. The IRS still wants its piece. So we have to talk about the beneficiary designation in terms of what will those tax consequences be, and based upon your macro plan, how could we possibly beneficiary designate that particular type of asset in the most beneficial way from a tax perspective. And with this, it's also a matter of talking about creditor or asset protection for the recipient, the beneficiary that you designate on this type of tax deferred asset. A relevant part of the conversation is providing for their asset protection over that inherited money. And that's a matter of how we handle the beneficiary designation. Checking account is another example of a type of asset where we may actually end up utilizing a payable on death designation. And typically when we do that as part of the guidance that I give to clients, it may be based upon having a trust-based plan. So having the bigger picture estate plan involve trust planning. And with the checking account, typically taking into account that most people have perhaps not a sizable amount that stays in that account, but it goes in and out monthly, and that they have automatic debits and automatic deposits set up that really would be a nuisance to have to update all of those. So even though for an estate planning and asset protection planning attorney, I may have laser focus on certain goals and certain priorities, and certainly financial advisors and investment advisors have their own that they're focused on as the top priorities. But one of the priorities that I always try to take into account is convenience. I'm certainly not trying to accomplish goals and make life much more difficult for clients. So with checking accounts, usually there's a lot of automatic debits, automatic deposits. We don't want you to have to update all of those. So that is something where I typically will guide clients that that asset can be made payable on death, but that's usually only when we're doing some sort of trust plan as the overarching estate plan. So another aspect of thinking through the nuances of beneficiary and payable on death designations is taking into account the type of estate plan. So what estate plan, as an overall plan, as a comprehensive plan, what type is this particular client putting together? So is the type of estate plan that they're utilizing, does it involve lifetime trust planning, such as a revocable trust? If that's the case, if that's the estate plan that we've put together for the client, then this usually will involve taking their assets and utilizing a mixture of approaches. So of course, part of it depends on what type of asset we're talking about, and everyone has a different asset picture. But starting with the types of assets, and then if the estate plan involves lifetime trust planning, usually we do some of the assets with beneficiary designations, if that's appropriate. Maybe do some with payable on death designations, as I just mentioned with the checking account. And then with some, it's a matter of actually retitling accounts or retitling assets. So the type of estate plan, if it involves lifetime trust planning, usually involves a mixture of beneficiary or payable on death designations, along with other approaches to the assets, depending on what the assets are. If the type of estate plan is very simple, so that's sometimes true. Sometimes people do have a very simple estate plan because they have a very simple asset picture and very simple intentions with regard to what they want to happen after death. And in that case, when there are minimal assets and minimal risks, we may rely heavily on simply utilizing beneficiary and payable on death designations on the assets. If there are testamentary trusts that are part of the estate plan, by which I mean the intention is that after death, there will be trusts that come into existence at that time to hold assets for the benefit of after death beneficiaries, testamentary trusts as part of a plan. If that's part of your estate plan, then it's a matter of determining, is this a testamentary trust that's being set up under your will or under your own lifetime trust? Or is this its own trust, which we call a standalone trust? It exists independently of your other documents. If that's part of the estate plan, and depending upon those questions and those details, and then taking into account the type of asset, and unfortunately, often the specific financial institution, we have to take all of those factors into account in determining the appropriate use of beneficiary designations or payable on death designations for your assets. And I mentioned the financial institution itself because, as everyone has experienced, I am sure, different financial institutions have different rules, different approaches to handling things, and they often get to set that for themselves. So what I'm able to do as an estate and asset protection planning attorney is give guidance. And if I have the assistance of the client's financial advisor, which is frequently a very useful source of assistance, together we can typically identify what we're going to be able to do based upon the particular financial institutions where the client has assets. Unfortunately, that's not always the case. And sometimes what happens is that we move forward with a plan and with the intention to implement certain types of asset alignment, and find that financial institutions may reject the proposed plan for how to structure that asset, and may instead lead us to have to do a slightly different type of planning or approach it in a different way in order to accomplish the client's estate planning goals, while also taking into account that particular financial institution's rules and requirements. Again, it's a macro perspective. It requires the input of various professionals, but ultimately the goal is the intention, and we do everything that we can to get there, taking all of that into account. Then we have the consideration of the specific beneficiaries for whom we are planning. So examples of specific beneficiaries that may have an impact on the conversation regarding beneficiary and payable on death designations. When is it appropriate to utilize that structure, and how? One consideration is the beneficiary a spouse or a non-spouse? This has an impact on when and how we may utilize the beneficiary designation on an asset. As I already mentioned, is the beneficiary that we're leaving money to, is this a testamentary trust or a standalone trust? So is this a trust that only comes into existence after someone passes away under the terms of their will or their living trust? Or is this a trust that stands on its own, that exists currently and will be able to receive money after someone's passing? So that's part of the conversation in terms of, is the specific beneficiary being covered under a testamentary trust or a standalone trust? Because then that can lead to what financial institutions may or may not allow with the beneficiary designation. And it's always vital that we talk about special circumstances regarding your intended beneficiaries. Is the beneficiary a spendthrift? Do they have special needs, or are they receiving government assistance? Have they been through a divorce, or are they currently going through a divorce? Are they a minor? These are all details that we have to take into account with regard to your specific intended beneficiaries and the appropriate way to utilize beneficiary designations or payable on death when those are the nuances that we have to take into account with regard to your intended beneficiaries.
Olivia,
Which
can we
leads,
pause for a moment?
oh yes,
Absolutely,
Jeff, sorry.
Oh, no, it's fine. So a couple questions. One is from our good friend, Roseanne. I think you remember Roseanne. And that question is, for a POD checking account, do you make the beneficiary the trust for an individual?
Well, first of all, I should have said I'll take questions from anyone except Roseanne. But now that you've already asked the question, I suppose I'll answer. So the answer to that is that it really does depend, but to try to give clarity on that answer, if you have a revocable trust, then my recommendation is that you make your checking account payable on death to the revocable trust. And the reason, and this is actually a very good question because this is another source of confusion, when I guide clients to make an account payable on death to their trust, they frequently say, but my trust when I die is supposed to go to my children. So why would I not just make my account payable on death to my children directly and skip that step? And the answer is, first of all that I can do is give you guidance, but you ultimately make the decision on what you want to do. But the reason for my recommendation is that the trust, and I can only comment on trusts that I've created because of course I can't comment on the quality of other trusts from other attorneys, but in the trust that I create, the trust document has safety net provisions built into it that basically say, if at the time a beneficiary receives from this trust, that beneficiary is incapacitated, underage, on government assistance that they would lose if they inherited a chunk of money, if those are applicable circumstances at the time, then the trustee has discretion not to just give the money to that beneficiary who may lose their government assistance because of receiving that money, or who may, because they are incapacitated, not be able to manage money and potentially lead to a guardianship for them. Or if they're underage and you get to dictate that age, but perhaps you don't want someone who's under a certain age to receive money from your estate. Those safety nets give the trustee discretion at the point in time that it's relevant, which you have no way of predicting. So by designating it or making it payable on death to your revocable trust, what you're doing is making sure that that money will be subject to those safety net provisions in case they're applicable or pertinent at the time. And that's the reason that I recommend doing it that way. Another reason is that frequently people have testamentary trusts set up under their will or under their revocable trust, where they have decided to leave the money for their children or for whomever they're leaving their estate to. They've chosen to structure that in a way that the beneficiaries are actually going to inherit in further testamentary trust for the purpose of asset protection. Or maybe they're inheriting a supplemental needs trust for the purpose of protecting their eligibility for government assistance. And the only way to make sure that your checking account funds funnel into those inherited testamentary protective trusts is to make sure that the funds actually go under the terms of your trust. And that requires making it payable on death to the trust itself. But there are times certainly where perhaps the checking account especially is not a huge amount. And so leaving that outright, if you were to just make it payable on death directly to your children or directly to your sisters or whatever the case may be, it's not a huge amount perhaps, and therefore that's not a big risk to worry about. So I hope that helps answer the question, Roseanne, but it really requires a little bit more nuanced review, but those are general statements on why I guide people in a particular direction.
Well, thank you, Olivia. That is an excellent answer, and that's why we're all here today. So one more question that was emailed to me from a friend of the firm that's on here today. So the question is, I have managed my portfolio my entire life and am recently retired. I am considering turning this over to a financial advisor. Where should I begin the search for an advisor, and what are your thoughts about this?
Well, that's a very good question. And what I would say is, as with any time a professional advisor is chosen, it is certainly a good starting point to have referrals from other trusted advisors. So when you have a relationship with any type of trusted advisor in estate planning or our particular field of the law, or in finance or tax, those are the appropriate professionals to start with to ask, who would you refer me to? And what are some good contacts that you might be able to provide? And when I do that with clients, when clients ask me that question, frequently the conversation that I have with them is taking into account all of their particulars. So everything that you just read, Jeff, those are part of the particulars that I would take into account. But there's a little bit more to it that I would want to discuss in order to be able to then provide some names that I would recommend. So please, individual who asked that question, feel free to reach out to me, and I would be more than happy to have that conversation with you and give you some recommendations. But beyond that, then I certainly recommend, as with any professional, as with any advisor, that you interview and talk with different people in order to determine whether you like them and trust them and want to invest your money with them. So that would be my recommended approach. But the last thing I'll say about that is, and that's one of the things I'm going to cover at the end of my presentation, I highly recommend that you proceed with your current thinking, because part of what many people say to me is, well, I've invested my own money for years and it's been fine. Or I have all of my money invested with this particular financial institution and they're doing fine by me. So I don't really see the need in bringing in an actual professional financial advisor as an independent advisor as part of my team. I'm going to talk more on a later slide about why I find that such a vital piece of your overall advisory team. And I will talk in more detail about that, but let me just say for the moment, I highly recommend that you do get a financial advisor on board as part of your team. So I'm glad that you're headed in that direction, and please reach out to me so we can talk about some potential options that I might give you.
Thanks, Olivia. No other questions right now. Thank you.
Great, thank you. So a statement that I have heard a number of times is, what does the statement, don't leave your 401k or IRA to your minor child or grandchild, really mean? And of course, I apologize, that was missaid. I've heard the statement, don't leave your 401k or IRA to your minor child or grandchild. What does that mean? Let's get a little bit more nuanced and a little bit more granular about what that statement really means. Because again, if the starting point is your goal, and your goal is that you want to leave money for your minor child or your grandchild or any minor, if that's your goal, then let's talk about the way to accomplish that goal, rather than simply stopping at it's not possible or simply don't do it. So what does this statement mean? Well, what this is really meaning is that a minor, which in the state of Maryland means someone under the age of 18, a minor cannot own assets. They cannot own property, they cannot own assets. So what happens when a minor is gifted or inherits assets or property without a bigger, better structure in place? When assets are left directly to a minor person, then what ends up happening is a guardianship in the court has to be pursued and established. So the court has to be involved in establishing a guardianship of the property of the minor. First of all, anytime the court is involved, it unavoidably adds headache. That's just the reality of it. They do their best and they do an amazing job. I'm casting no aspersions on any court or judge, but it's just an additional complication that no one wants to deal with. And to be honest, the court doesn't want to deal with it either. So what we're worried about when we talk about leaving property or money to a minor is really the aspect of having the court have to be a part of a guardianship proceeding over the minor's property. Not to mention, most minors, even if they could actually own property, probably shouldn't. I don't know when you all became financially mature, but it certainly did not happen for me under the age of 18, and I would argue not for quite some time thereafter. So what we're really talking about when we talk about wanting to prevent or avoid a minor from inheriting assets is not wanting the risk of the guardianship proceeding that would have to take place in the courts and the risk of having someone who may be not financially mature or responsible receive your money or receive your property. Sometimes people's choice around this risk or this issue, two things. Sometimes people simply do not leave money or property to a minor, even though they want the money or the property to go to that person and to benefit that person, because they're simply told, oh no, don't ever leave your 401k to your minor grandchild, then they just don't do it. And that's a shame, because then that means that their goals are not being accomplished. There are ways around that. We'll talk about it. Another way that people sometimes navigate around this is by designating assets to someone else instead. I do not ever recommend this approach. The risks of designating your assets to someone else, with the idea being that you have a gentleman or a gentlewoman's agreement that they'll use those assets to care for your intended beneficiary. The risks are now that money is that person's money. So if they get sued, or if they get divorced, or if they have any creditor issue, the money that you gave to them with the intention that they would use it for someone else, your minor child, your minor grandchild, now they've lost the money to their own creditors or their own financial challenges. That wasn't your intention. That's a major risk of doing the plan that way. Another risk is that they die, and that money is part of their estate. You left it to them, but they can only use it to care for your intended beneficiary if they're still alive. If they die, that money that was yours, that you had particular intentions for, has now gone under their estate. So whatever their estate plan says, that's where that money would go. If they have no estate plan, which Jeff and I can tell you, that's a very large segment of the population that do not have an estate plan at all, that would mean that then your money would go, according to the laws of Maryland, to the people who are going to inherit from that person based upon the statutory designations. So those are the risks of designating assets to someone else with the intention that they will use them for your actual intended beneficiary. This also happens when people have special needs. So I worked with someone at one point whose father left all of the money to her with the intention that she would use it to take care of her sibling who had challenges of his own and really couldn't manage money. His intentions were good. He didn't take into account the risks. I sense that he probably didn't have professional guidance to understand that there are more appropriate ways to structure things. So what are those more appropriate ways? Well, what we're really talking about is doing some type of trust planning. So the testamentary trusts that I've mentioned, the idea being that what you're doing is not leaving money or property directly to a minor or directly to someone who may be unable to manage money for themselves or who may be on government assistance. Instead, what you're doing is leaving money to a trust for the benefit of that minor or the benefit of that incapacitated or financially unable beneficiary. So the value of a robust estate plan is that we can actually help you accomplish your goals, even if those goals mean leaving property or money for the benefit of someone who either can't legally own property or who shouldn't. We can structure it so that you are still benefiting them without the risks that are inherent in simply leaving it outright to someone else with the understanding that they'll use it according to your intentions. So that's why I caution against, don't take things at face value. I agree. Don't leave your 401k to your minor grandchild. I absolutely agree with that. But let's not stop the conversation there. There's still a way to accomplish your goal. We just have to be a bit more nuanced about how we go about it. So tax and other considerations. As I say, tax is certainly always a relevant part of the conversation. And typically, if I ask the question, would you like to minimize or avoid tax? The answer is yes. So taking into account tax and other considerations when we're thinking about the appropriate estate plan and financial plan and how those overlap and what needs to be taken into account from both perspectives. So if someone has charitable inclinations, the legal documents that we may put into place are one thing. The legal structures that may dictate to which charitable organizations and in what structure or in what manner. But the part where a financial advisor is of great assistance and the piece where financial planning plays a part in this is what is the best asset to use to accomplish your charitable inclinations. Because charitable organizations don't pay tax on money or property that's left to them. And so if there are assets that you have that have tax consequences or tax considerations, then it's worth talking about. Perhaps those are the best assets to use to fund your charitable inclinations. Another part of the conversation with that is the timing. And this is really where I rely heavily on the assistance of financial advisors, because the timing with charitable inclinations, would it make more sense for you to do some lifetime gifting, or is it best and appropriate to really just wait for an after-death distribution, or some combination of both? But that takes into account your tax exposure, your assets, and your intentions. And your options with charitable inclinations are to do things outright or in some sort of trust. There are charitable trusts that we put together that have various benefits that we take into account. When someone has charitable inclinations, it's just a matter of talking about what are your options for accomplishing those. Or a donor advised fund is sometimes utilized, and that's something where a financial advisor really comes in well to guide on that and discuss that option. So then when we're thinking about when someone has large 401k or IRA or TSP, any of those types of tax deferred assets. So there are lifetime income tax consequences that are relevant to this type of asset. And there are different ways that those lifetime tax consequences can be mitigated. And depending upon the after-death beneficiaries, there are tax impacts to take into account and to discuss your beneficiaries. What are the different tax consequences that those different beneficiaries may face inheriting this type of tax-deferred asset? And what are the options for mitigating that? There's the conversation about creditor protection. So many people know and many people don't know, but tax-deferred accounts, when they are your own and you have created them during your own lifetime, they are your own retirement account. Those are creditor protected. So those are asset protection vehicles that you have for yourself. And the same is true when that asset is inherited by a spouse. But something that changed in the law that's rather significant in the last 7 years is that those inherited assets are no longer protected when inherited by anyone other than a spouse. So what we have to talk about when someone has large tax-deferred assets is, to what extent does asset protection matter to you in terms of your non-spouse beneficiary inheriting this from you after your death, and what structure do we need to put into place to accomplish that? Everyone is probably aware of a very big change to the law with the impact on tax-deferred assets that happened at the end of last year. The Secure Act significantly changed how this type of an asset is inherited by a non-spouse. And so this has been a very busy year for a number of reasons. But one of the reasons this has been a very busy year has been because of the Secure Act, the impact that this has had on clients who have large tax-deferred accounts or assets, and the planning that we need to put into place in order to make sure that their goals continue to be accomplished even as the laws change. So that has particularly brought us in contact with many of our clients' financial advisors to try to get everything back on track following the passage of the Secure Act. Long-term care healthcare. So this is another area where this is a very relevant piece of what many people are worried about and what many people want to plan for is their long-term care healthcare and how to fund it. So I talked in the beginning about the goal of what your end-of-life care will look like, whether that's at home or how you want that to be handled. But the question that is equally relevant is, how will that be paid for? How will you fund your intentions in terms of your long-term care healthcare costs? And so with a financial advisor, I'm able to talk with clients about whether it's best to invest in long-term care insurance, or are there other investment vehicles that maybe have greater overall returns where it really would be more wise for you to put your investable assets. And then the part where I can really come in and play a part is, what asset protection options do we have, particularly in light of the possibility of Medicaid to help pay for skilled nursing or other government benefits that someone might be eligible for. And more than anything, there is planning that we can do at various points in life and at various points in this spectrum that are appropriate based upon that particular point in life. But all of that requires conversations and planning, taking into account your goals, your current life stage, your assets, and the risks and pros and cons of different options that you have in order for you to be able to make the decision about the appropriate path to take at this particular moment in time. And then estate, gift, and inheritance taxes. This is a relevant part of the conversation in terms of, what are these? When are they relevant? How much are they? And what are the options available to you for minimizing and hopefully avoiding them completely? These frequently involve asset-specific applications, and this is frequently just one of many considerations. It's not the only one. Sometimes it's not even the highest priority, but it should be a part of the conversation when we're talking about your goals, your assets, and how we can accomplish minimizing tax consequences based upon all of that, and putting the appropriate legal structure in place to ensure that that happens. So I said that I would get to my perspective on the financial advisor and what a vital part this can be in your advising team. So many people say, as I mentioned previously, oh, I've done fine with my own investing. I'm quite good at doing my own investing. The reality with that is that that's great, and I applaud that skill. I don't have it. I'm glad that you do. But what if you become incapacitated? And after your death, you knew what you were doing, you knew the intention behind it, but no one else does. This is particularly relevant if you become incapacitated. So one of the benefits, in my mind, to having a financial advisor as part of your team is that that person will be intimately familiar with the investment decisions that have been made, the reasons behind them, and will be able to cross the fence between when you're the one capable of making those decisions and giving those directions and having those conversations, and when someone may be stepping in to handle all of that on your behalf, such as your power of attorney or your trustee. So the financial advisor is able to cross that line between your capacity and your potential incapacity, and then the same thing after death. After your death, will your family or your designated executor or trustee have any idea about where your assets are, what your assets are, what your reasoning was for doing various things and taking various financial actions? If you are no longer able to communicate that, having a financial advisor who has been a part of that lifetime process will make such a tremendous difference in assisting the person who's now acting on your behalf with regard to your finances, and in providing such major comfort to your family and your beneficiaries and the people who are grieving and trying to navigate a world where now you are no longer able to give them guidance. A financial advisor is also someone with whom you can have, and frequently do have, a more personal relationship where they really know your family, know your concerns, know your goals, and are able to help guide you on all of that. And of course, I highly recommend that a financial advisor view an estate planning and asset protection planning attorney as an equally vital part of that team, because in order to help guide clients on accomplishing their goals in the best manner possible, it requires having input from both sides of the professional spectrum in terms of the financial and the legal. But another thing that I've observed is many people are very scared of what will happen, especially with their money, if they become incapacitated. The idea that someone else would be touching your money and able to access your money, whether it's your power of attorney or your trustee, that causes a lot of people a great deal of worry, understandably. And frequently what they ask is, will there be anyone making sure that this person is acting appropriately? And I tell them there is unfortunately no supervisor observing what a power of attorney is doing. There is no supervisor making sure that the person that you've given the power over your assets is in fact acting properly. They're supposed to under the law, but there is no supervisor to make sure that that happens. One of the things that a financial advisor can serve a great purpose in is that they are able to provide some of that objective oversight. They are keeping an eye on your accounts, and if they notice that something weird is going on or major withdrawals are being made or anything else that's out of the ordinary and that just simply does not look appropriate, you now have an additional person who is paying attention to that. And that's another source of great utility that I think that a financial advisor can provide, is that source of comfort. And ultimately, to ensure the success of your estate plan, I really view the success of someone's estate plan as something that can only be accomplished if I, as an estate planning attorney, am part of the planning in addition to the financial advisor that that client may have. And when clients don't have a financial advisor, it's something that I highly recommend that they think about hiring and bringing into their advisory team. And that's the last thing that I'll say. The ideal advisory team is one comprised of not only your attorney, but also your financial advisor and a tax advisor. And there are often times where the financial advisor and the tax advisor may be the same person or may be within the same firm and able to offer those services. But overall, an ideal advisory team is one where you are able to get input from all sides, legal, financial, and tax, in order to perfectly accomplish your goals and provide for protecting you against the risks and negative consequences that you may not be aware of if acting on your own. Any last questions, Jeff?
Well, thank you, Olivia. We do have a couple of last questions, and I'll say if anybody does have a burning question they'd like to get in, now is your time to do that. So thank you for a great presentation. We are going to have to revisit this one again, I am sure. So the first question that we have is there a Maryland inheritance tax issue on a non-lineal beneficiary of a life insurance policy?
Oh, that's an excellent question. The answer is no. And that's one of the reasons that I said when we are doing life insurance beneficiary designations, it's always a very good idea that we take into account the overall estate planning intentions and identify if there are any beneficiaries who would be subject to Maryland inheritance tax. Then would we be better off to leave them the life insurance money instead of some other asset to avoid that inheritance tax? But that requires, taking into account the macro perspective. So I wouldn't say that's always the appropriate choice. There are other things to take into account, but quite simply, the answer to that question is no. Leaving life insurance to a non-lineal beneficiary will not incur inheritance tax in Maryland.
Okay. Next question is, how does a testamentary trust under a will and a standalone trust function differently, and when should each be used?
So that's a very good question as well. And the answer to that is that some of the nuances that go into that decision making are, so one example that I'll give is when we're talking about doing a supplemental needs trust plan for a special needs child or grandchild or sister, any beneficiary. And when we're doing that type of plan, the intention behind that type of plan is driven by the beneficiary not being able, or perhaps simply shouldn't be able, to control their own money, or money that you're leaving for them rather. That's the first part of the conversation. The second part is, are they receiving government assistance, or will they be, or might they be, such that we want to make sure that their eligibility for that government assistance won't be harmed by money that might be left for them. And in that circumstance, what we're really talking about is implementing a supplemental needs trust, because that's the appropriate type of trust in that circumstance for that type of beneficiary. Then the question becomes, do we simply establish this as a testamentary trust under your will or under your revocable living trust or other type of trust that you're implementing during your lifetime? Or do we do this as its own standalone trust? And some of the conversations that I have are based upon, is anyone other than you intending to leave money to that particular beneficiary in that particular trust? And if that's the case, if there are going to be sources other than your estate where money will come from, then we really are talking about doing a standalone trust so that it exists now and is able to receive money from whomever may be designating their estate to it. So that's one reason we may choose to utilize a standalone trust in that circumstance. Another reason is because a standalone trust in and of itself is able to be more comprehensive. It's just the nature of it. A standalone trust has many more pages and many more details. It's a much more detailed and nuanced trust, whereas a testamentary one is typically written in a much simpler, more concise way. So that's goal driven. And that's all part of the conversation as well, is to what extent is your goal in doing this to provide for something that's much more comprehensive and detailed, where you get to dictate many more of the terms of how the trust is handled, versus maybe your goal is a little more simplistic, which is simply asset protection or something that's much more simplistic, but that you aren't as concerned about having a much more comprehensive, detailed trust. And of course, cost plays a role in it as well. Creating a standalone trust is more expensive than creating a testamentary trust because of the comprehensiveness. So it's a matter of talking through your goals and what you're trying to accomplish and your willingness to pay for accomplishing one versus the other. But ultimately in actual use and how they're actually carried out, is there significant difference? Really only to the extent of how much more detailed a standalone trust can be.
Okay, thank you. And last question, very similar to the previous question, but I'm going to ask it because it has a little bit of a difference. Regarding life insurance and annuities, is Maryland inheritance tax due if the named beneficiary is a non-relative, such as a friend?
So life insurance, the answer is no. There is not inheritance tax applied to life insurance death benefits for a friend or a non-relative. I don't know the answer on annuities, but I suspect that the answer is that yes, that would be subject to inheritance tax. The Maryland Code specifically identifies life insurance as not, but it has to be, as I said, handled in a particular way. So we should always talk about that more. But I don't believe that it specifies that about annuities. So I suspect that annuities would be subject to inheritance tax. But if you provide Jeff with your name and email, I'm happy to look that up and clarify.
Yes, absolutely. So you can always reach me here at Jeff, Jeff, at elvilleassociates.com, and you have Olivia's contact information here in the slide in front of you and in the presentation that I emailed everybody. So a virtual hand to Olivia, job well done. Again, we're gonna have to revisit this. I thought this was a great presentation, a lot of great information, and I'll be sending out the video of this presentation probably by the end of today, at the very latest tomorrow morning. We're going to be taking a bit of a break for the holidays from our webinar series. We're going to be coming back in full force in January. I think we have about 8 webinars on the calendar, including at least a couple of new webinars, including a focus on Medicaid offered by one of our elder law attorneys, Lindsay Moss, here at the firm, and also everything you always wanted to know about seniors real estate offered by the realtor at the Bob Lucido team, Victoria Hathaway. She is a wonderful person and a wonderful resource. I know that you will get a lot out of that. So if you've been thinking about planning or updating those documents but have been putting it off, you're in the majority, and that's okay. I'm not one for New Year's resolutions, but make it a point to put that on your calendar for the new year, and we're here to be a resource for you. And I'm sure that if you get that done, you'll feel so much better when you can cross it off your list. We're here to offer you peace of mind and create solutions for your needs here for your family and you. So we're happy to be here for you. And I'm going to stay on the call for just a few minutes for any non-legal questions that you might have. We appreciate it if you just take a minute or two to fill out that survey, that post-webinar feedback email that's going to come out to you. And also regarding financial advisors, which we talked a lot about, if you do have, it's like my lights just went out here at the firm. I think that means it's snowing. As I sit here in the dark, if you do have a need for a financial advisor, which we value greatly here, we have a lot of great relationships and are fortunate to know a lot of the very best ones in the area, please let us know, and we will be happy to provide a warm referral and introduction for you. I know Olivia works with some of the very best ones in the area too. So thank you again for being part of our Elville workshop series here. And since the lights are going out on me, I think that means it's time for a wrap. So have a great day and be safe, and thank you for your relationship with Elville & Associates. Have a great day, everybody.